Hello, chat. Funny seeing you guys here tonight. Hope everybody's doing well. We're just gonna go. We're going all night, chat. Not really all night, but we need a little bit to talk to. We need some levity. Besides, we can't just talk about the whole This can't be all we talk about. There's so much more funny shit out there, interesting stuff out there to talk about. So let's get to it. Patrick Tomlinson. You guys don't, well, for those of you new here, my name's Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area. And obviously, yes, we talk about like criminal related things, but tonight we're talking about a civil lawsuit. And this lawsuit has been filed by Patrick Tomlinson. Yes, the stalker child himself. And he has filed it against the city of Milwaukee because he has been swatted a ton of times, like a shitload, like a lot. And part of his biggest thing is it's not that they didn't show up, it's that they have showed up and that they've drug him out of the house and that he's been answering the door naked before because they come to get him and the police are being mean. So he's suing. And he sued back in February. We covered that part of it. We covered the initial complaint back in February. Since then, the city of Milwaukee filed a response to that. We're going to cover that tonight. And just recently, Patrick and his attorneys went ahead and filed a response to that. And we're going to cover that. Didn't he pay people to swat him? I don't think that's ever been proven, but yes, it's a very compelling theory. I think holds a lot of weight, holds a lot of water. Lofi says, I still don't know who the fuck Patrick Tomlinson is. He is a science fiction writer who generally turned into kind of like a LolCow and internet punching bag and shit magnet for being cringe. I mean, that's the best thing I could tell you. If you want to Google a little bit about him, you can. If you go on the farms, Kiwi Farms, there's a whole thing about Patrick Tomlinson. You can learn all about it. He totally paid the tour swats guys. I mean, that may come out because now they've figured him out. That may come out now. So, yeah, he better be careful. If he did, that's going to be a little rough. It's going to be a little rough if he got caught doing it. I am dear Tomlinson, my child. Yes, he's also accused of being a pepperoni aficionado and grinding people up in his basement and making them out of pepperoni if they're especially melanated. Why do we only cover losers? Well, because this is the funny stuff. This is the interesting things. I mean, somebody has to win and lose in a lawsuit. Hack says, enjoy prison, stalker. I don't think I'm going to enjoy it. I don't think I will. No, you. That's right. Reverso. Sonika says, not the pepperoni. No. All right, so here we go. Chat. So you're going to learn a lot. If you guys didn't read the complaint from before, you will understand a lot of what's being alleged here because the city has to respond to Patrick and say, no, you're full of shit. And here's our proof, and here's our argument why. So this is filed in federal court. And this is in the Eastern District of Wisconsin. So it's Nikki Robinson and Patrick Tomlinson. That's his wife. Why is this not? There we go. Okay, versus the city of Milwaukee. And that's got multiple parties here. Lyndon Evans is one of the big, he's one of the police officers who's been a big meanie to him. He's a big black man. So there might be some issues here. These are other parties that they've listed and other parties that have been listed out here. And this is the brief in support of the defendant's motion to dismiss under Federal Rules of Civil Procedure 12b-6. 12b-6 is merely where you're just stating they failed to state a claim upon which relief can be granted. And what does that ultimately mean? That just means, assuming everything that Patrick Tomlinson has told us is true, he's still not entitled to relief. Oh yes, we're gonna talk about those guys, the bank people, on Thursday. Um, those are hilarious. A big black man like Drex? No, a bigger, very robust and very swarthy and muscly black man. So the defendants hereby support their brief. Once again, according to rule of Federal Procedure 12b6. So Patrick and his wife bring various claims against City of Milwaukee and numerous officers under 42 U.S.C. 1983. So that's a deprivation of rights under the color of law. Stating their purpose of doing so is to vindicate the violation of plaintiffs' constitutional rights and effect change through punitive damages by punishing the defendants for their egregious conduct, with the hope the punishment is significant enough to prevent this from happening again in the future. Plaintiffs characterize the routine police emergency responses as illegal searches and seizures of their home and persons. And they cite a bunch of times that the police were called to their home, and they're calling these all a bunch of illegal searches and seizures. They also point out that they're illegal searches of their curtilage. And guys, if you don't know what curtilage means that area around your home, right there. So imagine like if you were like in a more you live in the suburbs or something like that, and you have like a fence up right around the edge of your house. It's that area right around your house where you're always out and about doing stuff. That's a curtilage. Additionally, they allege a Monell claim and claims of officer failure to intervene. So a Monell claim, guys, is a failure to train. And a Monell claim is that they set up an environment where they weren't training and educating their people well enough, and that it's on the city because of that. The city created the poor training environment. And then officers' failure to intervene. And that's number 4. And that one's going to be tough because remember, officers don't have a duty to intervene. Remember, we have DeShaney versus Winnebago County, and then we have Castle Rock v. Gonzalez. The cops have no duty to intervene. The plaintiff appears to concede the police action was taken in direct response to calls that were made for emergency services, and even acknowledge the police are unwitting tools of the bad actors who make false claims and requesting emergency services, and the police have no choice but to take these fake calls at face value. So yes, Patrick Tomlinson was getting the shit swatted out of him and kept on having problems. So they were swatting, claiming, murders and suicides were happening there, all kinds of stuff. So the police have to show up. And they point out that, and they also include, many of the cops who have responded have been kind, understanding, and compassionate. However, they appear to allege because their situation involved a number of swatting calls, the police should have deviated from standard protocol and treated the request to their home differently, that any rational police force would have recognized at some point any calls involving their home were clearly false and should not be taken seriously, and would have implemented some sort of policy to avoid further swatting activity. Plaintiffs claim they tried to work with the city of Milwaukee to stop this, but the city failed to adapt a policy or train its officers on how to prevent stalkers and their children, I would presume, their progeny, from using the police department as a tool of terror. So they point out that there are following claims. There's an unlawful search and seizure and a Monell claim against the city for one of the swatting incidents. And they go through all of these here, and you see all those names we saw before. So you see like Nicole Plevek, she was listed above. John Kohler, Jacob Wasacek, Officer Fida Mustafa, Sergeant Lyndon Evans, the bull himself, Christian Garrido, Bradley Orlando. That sounds like a porn. Isn't there a porn star named Bradley Orlando or something like that? Sounds like a porn star name. Nathaniel Peterson, Lyndon Evans again, Paul Vento. There's a bunch of these, and these cover a bunch of things that happened, particularly in 2023. You notice 2023. Some stuff in 2022 here and there, but a lot of 2022, 2023. So the standards of review. This permits a party to dismiss a complaint if they fail to state a claim upon which relief may be granted. This is just testing the sufficiency of the complaint, not the merits of the case. And that's true. Does the complaint show a way upon which Patrick Tomlinson could be granted relief by a court. Now, whether or not his case is likely to succeed at trial, that's a different standard. So the complaint must include a short and plain statement the claim is showing the pleader is entitled to relief. To survive a motion to dismiss, they must state a claim to relief that is plausible upon its face. And facial plausibility is when the plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. The plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility the defendant has acted unlawfully. And they say when the complaint just pleads facts that are consistent with the liability, it stops short of the line of plausibility to relief. And you guys will see this routinely in filings. This quote, threadbare recitals of the elements of a cause of action supported by mere conclusory statements are insufficient to withstand the 12b6 motion. This is from Ashcroft v. Iqbal. And this is a major case in civil procedure. There's also a Twombly. I think yes. Then we said Bell Atlantic Corporation versus Twombly. And then you see Iqbal here. Iqbal and Twombly, the civil procedure are called like Twickball. The things and the issues they do and these are landmark cases, like watershed events for civil procedure and how things are conducted. These two cases are massive in what they changed. So you will see them everywhere. You'll see them in state level actions as well. They point out courts can consider any facts set forth in the complaint that undermine the claim. A motion to dismiss can be based upon the complaint itself, documents attached to the complaint, documents are critical to the complaint and referred to in it, and information that's subject to proper judicial notice. And judicial notice is things the court could take notice of without having to be proven or needing evidentiary value for. Okay, so for example, you can take notice that the 3rd of July was a Tuesday. The court, that's not a fact that has to be proven. That's not a fact in question. The 3rd was a Tuesday. Okay. That's one as well. Or you could say like this house is at 1234 Elm Street. I love male porn stars. Yeah, thank you. Baldo v. State will make history. Oh. Super Wiener says, if any of you know him, Paul Harrell passed recently. Rip. Yeah. The video's up. His brother Ron is on there. Yeah, Paul definitely died. And then nice podcast, stupid. It says, rumor has it, Lyndon Evans took a liking to Nikki. Ooh. I'm sure. All those big strapping men in their handcuffs. So now we get to the arguments here, okay? The alleged swatting incidents do not constitute a violation because exigent circumstances existed justifying, if not requiring, the police actions. They characterize the police as illegal searches and seizures of their homes or persons and illegal searches of their curtilage. Plaintiffs allege that their internet bullies were engaged in swatting, which they define as 911 calls that are lied to provoke a dangerous police response. Well, that's true. Plaintiffs can see that normally in situations the police have become unwitting tools of the actors, and they have no choice. Now, once again, that was already stated above, but now they're really hammering the points. And they say that the police should have realized they were clearly false and not be taken seriously. And yes, essentially the plaintiffs allege that by continuing to take the calls seriously and respond as if they were emergencies, the defendant's actions constituted search and seizure in violation or the Fourth Amendment, that at some point the police should have realized the plaintiffs were targets of swatters and should have automatically discounted or disregarded their calls when deciding whether exigent circumstances existed for all the alleged searches and seizures. They're assuming for the sake of this motion to dismiss, and this is where they point out, we're like, assuming for the motion to dismiss that all facts alleged by the plaintiff are true, and that's how you have to do this. You look at this in the light most favorable to the non-moving party. So in this situation, the defendant is the one moving for the motion to dismiss. So the plaintiff, all evidence is viewed in favor to them. All inferences and doubts, and like if you're 50-50, and all inferences are drawn in favor of the non-moving party. You give them every benefit of the doubt, and you have to. You presume what they're saying is true, and then determine as a judge, can I grant them relief legally? If you can, then it survives. If you can't, then it's done. All right. So they point out that they said the plaintiffs have failed to establish the defendant violated constitutional rights for the following reasons. The call center operators and first responders have a duty to treat all emergency calls for service as true emergencies and to route and respond to them accordingly. And they point out that case precedent is clear that calls for emergency service should be treated as emergencies. It is not the place of the call center operators or first responders to speculate about the veracity of the report. And they're citing in the Seventh Circuit. Wisconsin is in the Seventh Circuit, the Seventh Federal Circuit. So they're citing case law. They're citing, like, we have to take it seriously. Look, Judge, the court above us tells us we have to. 911 calls reporting an emergency can be enough to support warrantless searches under the exigent circumstances exception, particularly where as a caller identified himself. And they point out that the efficient and effective use of emergency networks requires the police to be able to respond to such calls quickly and without unnecessary second guessing. And they point out and this is where, okay, the business of policemen and firemen is to act. Well, no, the business of policemen and firemen is to save fucking lives and uphold the public order. Not to speculate or meditate on whether the report is correct. People could well die in emergencies if police try to act with the calm deliberation associated with the judicial process. Well, they'd also kill a lot less people, too. I'm just saying. And they cite this case, United States v. Drake, that the reporting of an ongoing emergency prevents special problems and obligations on the police. And when the police respond to an emergency as a result of a 911 call, the exigencies of the situation do not require further pre-response verification of the caller's identity before action's taken. They state that requiring further indicia of reliability would only jeopardize the usefulness of the 911 system and the ability of officers to prevent further damage. And they point out a 911 system is designed to provide an emergency response to telephonic tips, could not operate. The police had to verify the identity of every caller and test their claim to scene crimes in progress. Yeah, I mean, it also killed Crime Stoppers. They point out, though, yes, there's greater confidence when the police know a caller's identity. Yet, as a practical matter, a name given by a caller does not make any tip less anonymous. And it would undermine the goal of 911 if you had to prove your identity. I mean, imagine that. You're like, if you had to do that, if you had to do your identity there, that would be really, really bad. Because think about it, you're trying to get things done. Oh my God, I'm bleeding to death. Help me, 911. And it's like, please confirm your identity. How do you prove it's you? That would be absolutely horrible. So you have to think about it that way. How would that work? How would you have to prove to 911 that it's you? Hold on, chat. What's that? What's that? Well, that's a good point. You have to prove you have insurance before the doctor looks at you. But if you roll into the hospital dying, they do have to take care of you first and then ask questions later. So hold on here, chat. I need to fix something. Yes, ASAP, my apology. I thought that thing was in there. So I appreciate your concern. I thought there was context, but also if you're reading along with us, I can give you a lot of context here. Now, yes, it is interesting in this situation. These police and firefighters are talking about their obligation is protect life. And it's like, well, no, your obligations uphold, like, show up sometimes. So in the Seventh Circuit, they point out that the police don't have to verify identity. And they said doing so would have required them to act unreasonable, saying that 911 calls are brief and anonymous precisely because the speaker is at risk and must conceal their call. And they say that any sanctioning to stop that might enable a person seeking to harass another to set in motion an intrusive, embarrassing search. Um, and yeah, it's never a good idea. It's never a good idea. Um, you don't want the 911 caller determining if you're telling the truth or not. I want them to come, please help me. Well, if that 911 goes, yeah, I don't think so. You know what? He's really not sick. Hold on. Ignore him. Do you really want that? No, you wouldn't want that. That would be awful and scary if that were to happen. Smug cheese in my own country, once we dead, the government can announce it, and the press will support it, and they will lock you up for seeing it. What country is that? Canada? That sucks. So, hmm. So they say, although governments are generally not liable under Monell for failing to provide for public safety or failure to protect, even if they're aware a danger exists, unless the state created danger. And remember, guys, if the state didn't cause the problems, DeShaney versus Winnebago County is a controlling case from 1989. Although it's funny, in DeShaney, it's because the children's services workers fucked up. It was state created. But notice, even when the state created the danger, the Supreme Court determined there was no danger that the state had created. They say state law suggests that when a 911 call communicates a known and present danger, call center operators have a duty to promptly relay information to the local law enforcement agency, and the local law enforcement agency has a duty to promptly dispatch an officer to investigate. And failure to do so may subject the operator and or responding officers to civil liability. Now, there are states where they can do this. The Supreme Court has said, like, in general, you just can't sue people, okay, in federal court, but a state could enhance that and say, no, you are liable if they want to. And here in Wisconsin, it sounds like there's a failure to do so. You could be sued for it. So, and these are cases that they're just reinforcing things with here. And they found that there was no municipal immunity because the paramedics waited 20 minutes before trying to extricate a drowning victim. Oof, that's no good. Um, this one here is talking about a deputy sheriff exercising his discretion to foregoing efforts because there is a known and compelling danger that his waterborne rescue was absolute and certain and imperative follow up instead by checking the shoreline and boat landings for the boat in question. I mean, so yeah, he has a lot of authority to run around and do what they want. Jay says, do I sleep? Yeah, we do. We do sleep. Yeah. So they're pointing out that although they say the defendant should have treated emergency calls differently than it treated other calls, should be dismissed for failure to state a claim upon which relief cannot be granted. They point out the calls for service involved situations that were exigent. And they said any reasonable officer would have known there was no probable cause to believe crimes were committed or someone was in danger. And that any officer would have known there was not an exigency. And they claim the searches were without exigency. They point out that's because the calls in the past were false. And they say there are a few cases that leave the possibility that there could be some scenario where 911 call standing alone would not be sufficient to establish exigent circumstances. None stand for plaintiff's position that a certain number of prior calls are subsequently determined to have been made renders all subsequent calls of otherwise of a serious nature non-exigent and bars responding officers from investigating. And that's fair. There is no crying wolf issue here. If they get a call, they have to respond. It doesn't matter how many there were before. They show up because they have to show up. And the exigencies are exigent circumstances allowing a warrantless search. And there's quite a few of them. You would like to hope there weren't many, but there's a lot of them. There's several exceptions which may justify a warrantless search of a home, including rendering emergency aid, rendering emergency assistance without a warrant to an injured occupant, or to protect someone from imminent injury. Yeah. So obviously, if you're at your home and the police looks in the window and you're lying there and the fire is raging, do you want the cop to say, well, I can't go in and rescue that guy because, hey, look, there's a fire, but I don't have a warrant. Oh, well, sorry, stalker child, you get burned today. No, we would never want that. So we have to go ahead and allow this because we want the police to help people. Now, that's a warrantless search. Yes. There are other ones. Obviously, to prevent the destruction of evidence, to engage in hot pursuit of a fleeing suspect, to prevent a suspect's escape, and to address the risk of danger to police. Olson allows that because they were chasing after suspects. They say the Fourth Amendment does not bar officers from making warrantless entries when they reasonably believe a person is within need of immediate aid. And that's fine. But the rest of these here, these are all fucking bullshit. If we were doing this right, all this right here, Curvy, California, U.S.V. Santana, Minnesota v. Olson. Fuck that. If I had my way, erase all that. Like, you don't just squeak. So can they help to protect an occupant from imminent injury? Cool. Save innocent people. Save innocent lives. Great. We'd want to get rid of that. But the rest of it, nope, they can all go away. Then there's a footnote here, and I think it's worth noting. It's interesting what they talk about. They point out it's worth noting that these calls were only false after police responded to the scene and investigated. So that nobody knew at the time. There was no way to know until the police searched. And the only way for them to do it would result in delays to emergency response. So no, nobody wants to do that. The safety of others is a concern when the police respond to a report of a crime in progress. And the police judge warrantless entry should be afforded an extra degree of deference. Yeah, no, I don't like that part. Remember, only for safety innocent people, not for the rest of this. Nope, don't like that. So the plaintiff's complaint briefly states the nature of two calls to the police, noting on July 25th that there was a murder hostage situation inside the home. In April of 2023 was for a shooting at the residence. Although plaintiff's amended complaint does not state the nature of the calls for emergency services on August 11th, September 12th, October 1st, November 4th, November 30th, March 20th, April 11th, and April 17th, it can be inferred that they were calls of very serious nature since, according to plaintiffs, they were instances of swatting, which entails calls to 911 that are made to provoke a police response that it's dangerous. It's because these are with the intention of provoking a SWAT team-like response. They necessarily involve the swatter making types of claims that would fall under the exigent circumstances exception to the warrant requirement. And that's true, because you're going to call and say that there's people out there. There are gunmen. There's somebody on the loose. Oh, no, we're in trouble. Please help us. All those things. Those are all the things that are being argued. So that is what they're doing here. All right. Sorry. I didn't mean to shut that off. My bad. And they point out the CAD reports, and they say if the reports that are attached, it's permitted to do so. The court can look at those. And they say it becomes clear the calls were in life-threatening emergencies or violent crimes that had just been committed and involved a likelihood of destruction of evidence. And they claim those are both exigent circumstances there. And they point out officers are entitled to take reasonable measures to ensure safety and welfare of subjects on a call for service and have no obligation to accept the subject's assurances that they can refrain from investigating upon the person requesting it, which makes sense. Hey, you don't have to look anymore, Mr. Policeman. Oh, okay, cool. Who are you? Oh, don't worry about it. No, it doesn't work that way. As much as we'd like to in the situation, it is a good thing that the police don't just go, oh, well, who are you? And they say, oh, somebody said we go home. Yes, thank you, Mr. Sketchy Man with a bag on a sack full of stereos on your back. So they point out, even if the cops had any reason to doubt the veracity of the reports, they were still entitled to investigate and take other measures to ensure the safety and welfare of the subjects of the complaint and were not required constitutionally to accept his assurances. So, and they point out this case here, U.S.V. Brown, where the police had legitimate concerns about somebody's safety. It's unreasonable to think the police would stand outside despite legitimate concerns about welfare unless they can hear screams. They also cite a case here of a domestic violence call where a wife called 911 in reference to domestic violence. Okay, she told officers to leave, and they said they have probable cause, need not cancel an investigation on request. So remember, they get there and they notice, okay, well, the lady shows up to the front door all beat up with a black eye. Oh, it's okay, officer, you can leave. Nope, we have probable cause to search and investigate. So, yes, Pat is into things. Yes, he's into a lot of things. Well, a lot of things are into him, too. Ooh. And they said it's further noted the wife's statement she was unharmed did not establish the fact there was no need for inquiry because domestic violence is such a very, very ongoing thing. Now, let me see here. Where is? Well, that's a big. We're just gonna get down to where they're talking again because that's a lot of. So they cite a couple of cases here. They say that, even though a domestic violence victim say they're fine and didn't appear to be injured, it's not uncommon for DV victims to deny an assault, especially with their abusers present. Very true. And they say that any reasonable, prudent officer who would have looked askance at the plaintiff's claim that his wife mistakenly dialed 911 and sought to investigate further by speaking with the caller to confirm she had, in fact, made a mistake was safe and secure. And they put out, and when the plaintiff left the front door and several minutes passed, his wife did not come to the door. This only heightened the officer's concern that there was probable cause to enter the backyard. to try to locate the wife and make sure she was safe because they're like, oh my God, you beat the fuck out of her. They also point out there's the combustible nature of domestic disputes, and they give cops a great latitude on how they handle them. Yeah, and it still needs to be chained back. Okay, yes. Sometimes DV cases are dangerous for them. Well, dangerous for everybody in that situation. They point out the officer's search did not constitute a search of the curtilage. And they point out walking onto the porch of the plaintiff's home and standing at their front door, physically to see them to ensure their safety, despite their assurances they were okay, is worth noting that the porch area outside of a front door is not considered curtilage. That's right. Your porch isn't curtilage, but all the way around your house, that's all curtilage. In the immediate vicinity of your house is called the curtilage. And this is an interesting way they phrase it. Courts have recognized the knocker on the front door is treated as an invitation or license to attempted entry, justifying ingress to the home by solicitors, hawkers, and peddlers of all kinds. Yes, it's a knock on the door and maybe we'll let you in. They point out that cops not armed with a warrant may approach a home and knock because there is no more than any private citizen can do. And that's the point with Kentucky v. King. Cops are allowed to knock on doors and talk to you, but also you're allowed to ignore them. And hold on here, chat. Some reason my lens just got all freaking can't see. I don't know why. No, I really can't see, so don't worry. I see some green lines very faintly, and it looks like somebody super chatted. I see a blue bar. That's all I can see right now. God, I get my haircut tomorrow. This feels so grand. I don't know how emo kids did it, because this would drive me crazy. My hair keep falling on my face. There's no way I could be like, I'm going to be dark and brooding like this. Nope. It's a lot more fun. Like, I'm going to have buzz cut and go play Counter-Strike in high school. Oh, God. I just want this hair to go away. Oh, my gosh. So they also point out cops are generally permitted to approach the back door of residence in an attempt to interview someone if the front door doesn't work. And they point out a plaintiff claiming an illegal search of the curtilage must establish the area constituted curtilage, with factors including the size of the area, how the plaintiff typically used the area, whether a fence enclosed the area, and whether plaintiff had taken any measures to protect the area from observation. So, yeah, was it fenced off? Do you have like arborvitaes growing? Is it, in between a shed in your house? Like, there's ways you can establish curtilage. But yes, in Patrick Tomlinson's case, they established the porch area is curtilage, but they point out that's not curtilage. And they haven't put forth any claims which can be relieved and can be granted based on the search of the curtilage. Accordingly, the claim should be dismissed. And they point out in their conclusion, because Patrick Tomlinson has impliedly acknowledged the existence of exigent circumstances by way of stating the police conduct was at issue was a result of swatting, because the police reports and CAD reports established the life-threatening nature, and because there's no legal authority, it states that a certain number of phone calls are determined to have been false, rendering all other calls impossible. We don't do that. Those don't exist. And they say, even if otherwise of a serious nature, suggesting exigent circumstances, non-exigent, and bars responding officers from investigating the threats, plaintiffs have failed to state any Fourth Amendment claims upon which relief may be granted. And it's very true. There wasn't a whole lot of Fourth Amendment arguments in there. And then they point out, I love how this is in all caps. There were no constitutional violations requiring officer intervention. Yelling. No, it's just the way they wanted to organize it. In their complaint, there's various complaints against officers for failure to intervene or stop the illegal searches. They point out that any police officer, whether supervisory or not, who is present and fails to intervene to prevent other officers from infringing on the rights of citizens is also liable under 1983. If that officer had reasonable opportunity to intervene to prevent harm from occurring, and the officer had to know that excessive force is being used, and that citizen has been unjustifiably arrested, or that a constitutional violation has been committed by law enforcement officials. So, as analyzed and discussed, the defendant officers did not violate the rights. And yeah, based on that, yeah, that's pretty clear. They point out the police actions were permissible and there was no need for any officers to intervene on the plaintiff's behalf to protect their rights. They had no reason to believe they were being violated, and in fact were not violated. So they're saying this claim should be dismissed. Do I smell burnt toast? No. Why? Did I just sound like I was... Did I just, like, do something? Did I just go blah, 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 all of a sudden and nobody say anything? So no, I don't smell burnt toast. And they say, regardless if any occurred, the defendants are shielded by the doctrine of qualified immunity because there was no precedent clearly establishing that multiple calls for emergency service renders all calls subsequent for service non-exigent. And they point out the thing that would always probably save the officer no matter what happened, even if they actually did do bad things under 1983, is qualified immunity. Basically, they can't do anything wrong unless it's shown that the official violated a statutory or constitutional right that was clearly established at the time of the conduct, meaning you'd have to show a case saying that you can't do this. So many public immunity cases get dismissed because of that. Like, sorry, there's no analog for it. Happens all the time. So they say qualified immunity exists to protect public servants from liability for reasonable mistakes while performing public duties. Well, we'll see how well that turned out. The United States Supreme Court stressed the importance of resolving immunity questions at the early stage of litigation and is an issue that should be decided by the court long before trial. Yep. So defeating qualified immunity, you need conduct violating constitutional rights or statutory rights, and that is clearly established at the time of the violation such that a reasonable official would understand what he is doing violates that right. Now, they point out that there's a case, Pearson v. California. They point out that begin with the constitutional violations, but they are also free to consider first whether the right is clearly established if it will conserve judicial resources. And yeah, sometimes that happens right away. They said whether the law was established at a specific time is a question of law that must be answered by the court as opposed to jury. And they say that the police cannot have violated a clearly established right unless the right's contours were sufficiently definite that a reasonable official in the defendant's shoes would have understood he was violating it. I mean, that's where you're going to have to understand. You'd have to show that you understood you were violating a law at the time you're doing it, or it's clearly established. And they say, in other words, existing precedent must have been placed the statutory constitutional question by the official beyond debate. And they talk about in determining whether a right was clearly established, the Supreme Court has repeatedly told courts not to define the established law at a high level of generality. They said that doing so avoids a crucial question of whether an official acted responsibly in the particular circumstances that he or she faced. What do you guys say I'm stroking? What's going on? Am I like stuttering or something? Hmm. Hold on, chat. Is there something wrong, or am I just saying stuff goofy? Okay, somebody's asked someone stroking. Is like, there's something wrong on my end? Okay. Well, yeah, I don't know either. So, well, they're trolling you. Some people should. Well, I don't know. I don't think people are. I was just like, that was weird. Okay. So the clearly established law must be particularized to the facts of the case. Otherwise, plaintiffs would be able to convert the ruling qualified immunity into a rule virtually unqualified liability by alleging violations of extremely extract rights. Yeah. Well, things have gone so bad the other way, though. It's a complete mess. They point out there were no constitutional violations because there were no exigent circumstances justifying the alleged warrants. They said even if the plaintiffs could establish a constitutional violation, defendants are shielded by the doctrine of qualified immunity. And yes, those people were all shielded in one form or another, whether they were attorneys or not. Everybody's going to be protected there. Yeah, everybody's going to be protected here. The government officials, everyone's going to have immunity. The police are going to have immunity. The people in charge of writing these policies are going to have immunity. The attorneys, everybody. I'm stroking a baldo. So it doesn't matter. All the government officials would have access to it. There's yeah, everybody. Remember, it's not just police. Not just police get qualified immunity. A lot of people can get access to qualified immunity. So smug cheese is almost every right from the USA isn't here in the UK, but qualified immunity is. That's not a surprise, but I mean, you've had the king would never let you sue people anyway. So and they state, any reasonable officer would have known there was not reasonable probable cause to believe a crime was committed. Any reasonable officer would have known there was not an exigency, but that's not true. That's not true. So they're pointing out that because the previous calls were later determined to be bullshit. Well, they said there's no clearly established law that states repeated calls for emergency that are determined to be false, even if they're false or of a serious nature, should be disregarded or treated as not serious, and that a failure to do so constitutes a Fourth Amendment violation. So notice they're saying like there's nothing there that says if we don't follow like our calls and we don't respond, well, that's that's a Fourth Amendment issue. No, they don't have that. And not only that, you wouldn't want that. That would be insane to have. They point out there was a case involving a search during a 911 call, despite a bogus 911 call stating almost the same thing a week prior. And they said that, because of the additional information, they're like, nope, that's not true. That's not going to help. And they say perhaps plaintiff believes that their case is that case. Even if this court were to find it objectively reasonable for officers to continue to take the call seriously and investigate accordingly, in light of prior history calls of false calls, the defendants are entitled to qualified immunity since the law was not clearly established at the time, and this would be a case of first impression. Now, if it's not clearly established, because this fact pattern has never happened. So literally, if you're suing under 1983 in a lot of situations, they would have had to have done the exact same thing to you, someone else, and no, they couldn't have done that. So the way they beat you, or how they beat you, or how many times you were kicked, would be compared. They also point out that the officers acting unreasonably is in conflict with existing case law. They point out that a homeowner's argument police cannot take steps to protect a caller's safety unless they know the reliability and identity would require them to act unreasonably. Yeah, it's just I get what you're saying, but it wouldn't work for the rest of us in the real world. And they point out the 911 calls are brief, anonymous, and the speaker's at risk. You have to conceal it. Yep. And they point out there's a conflict and ambiguity in the law, means qualified immunity takes over. They point out there was no clearly established right that was violated, and accordingly, this should be entitled to qualified immunity. And yes, that would dismiss everything as well. Now I talk about the Monell claims. So the Monell claims are the ones involving training. And once again, they rehash all of this here about the unwitting tools of bad actors, that they have no choice to take these fake calls at face value. Well, yeah, and they point out that it's the city of Milwaukee's failure to train or supervise its officers and its failure to implement any policy to prevent plaintiffs from being swatted was a direct cause or moving force behind the violation of their Fourth Amendment rights. And this is a Monell claim here. That top part, a failure to adequately train. They didn't properly train them. And then apparently Monell also includes supervising now. So that is what yeah, on paper they violate rights regularly. Oh, well, they do it all the fucking time. They do it all the time. They point out the plaintiffs have claimed they tried to work with the city to stop this, but the city failed to adopt a policy or train its officers on how to prevent stalkers from using the police department as a cold tool of terror. And they say municipality is liable in a 1983 claim under Monell versus the Department of Social Services of the City of New York. That's the entire Monell case. If the violation was caused by an express city policy, a widespread through unwritten custom or practice, or 3, a decision by a municipal agent with final policymaking authority. So, yes, little deviations could cause problems, even if there's already like the police are following national standards. If they come through and they have an unwritten custom or practice, well, that can lead to a problem where, oh, we've always done it this way, or we've always dealt with this. And it's like, I don't know about that, guys. That's not exactly what we're looking for there. So they point out to establish a policy or custom, you must allege a pattern of specific incidents that support the general allegation of a custom or policy. And they say further, to demonstrate a municipality is liable, they must show the policymakers were deliberately indifferent as to the known or obvious consequences of that policy. So you have to show that's what's going on, and you have to show that the city people involved are like, meh. They're like, screw it, it works, good enough for government work, tee hee hee. And if you do that, well, then you can establish that element of, oh, there it was. Sorry. So almost any American could legally challenge your government. Yeah, you could. Yes, and they're locking up people in Britain for memes now. Yes, they are. And real quick, down forward punch. Sorry, trying to come back to this now. Is saying, do you know if it's illegal for someone in Milwaukee, Wisconsin to operate a non-sanctioned pepperoni factory? Asking for someone who owns an Airbnb Also, Patrick is a two-sink man. Shout out to Dan M. Well, I mean, there's nothing wrong with running your own pepperoni factories. It's just about whether or not you want to be involved. And the next podcast, stupid, says the SWAT calls are coming from inside the hovel. Run, no! The SWAT calls are coming from inside the pepperonis. Oh no! They can talk. They say and getting back to this now, in other words, the government officials must have been aware of the risk created by the customer practice and must have failed to take the steps to protect the plaintiff. And they say under this stringent standard, it is not enough to demonstrate policymakers could or even should have been aware because it occurred more than once. And they say that although the Seventh Circuit hasn't adopted blight right rules for what constitutes a widespread customer practice, it's clear that a single incident or even 3 incidents do not suffice. And they rehash some of the issues here that in the amended complaint that they point out that there were emergency services were extremely serious and they were exigent in the nature and is inherent in swatting calls. They say where no constitutional violations occurred. The claims that any violations were caused by the city of Milwaukee's failure to implement any policy, practice, or procedure should be dismissed for failure to state a claim upon which relief can be granted. And that makes sense. If they're already destroying this, saying there are no constitutional issues, they could keep going back to that saying there are no constitutional issues. There are no constitutional issues. There are no constitutional issues. J-Rock says, how many times have Patrick Tomlinson swatted? Like, total and forever, they're like 1 million. But in this recent one, he cited only 53. But he's been swatted a shitload. And there are allegations he helped pay for that himself. Suzanne says, hello. Hi, Suzanne. And they say that, this idea that the police should have implemented a policy to take calls that were in their situation less seriously, turns out to be false and has no legal support. And they say existing case precedent contradicts their assertions and suggests calling for an emergency service should be treated as an emergency and then, let them decide when they get there. So that's why if you ever hear somebody like, the ambulance comes out of the fire department, it's like it's sent. Woo, wee woo, wee woo, wee woo, wee woo. Then they pull up and they're like, I guess it's not a big wee woo time. Somebody just needs a Band-Aid. Okay, well, they take their time. And they say ultimately that it's not the place of the call system operator to speculate about veracity of a report. And then it's in conclusion, they say that they want the court to grant this motion to dismiss and dismiss all claims against all defendants with prejudice. So this was done on August 24th. Or I'm sorry, August 2024. Alligator News says, any update on I got so high? So I got high civil. Oh, you mean Afro Man. You know what? Here we go. Well, Adams County Courts. If you guys don't know that, the singer Afro Man has sued his local sheriff's office for abusing his privacy of his home and conducting a bullshit warrant raid. Let's see here. Okay. All right, this is... Looks like it's it. Yeah, guys, nothing... No, there's there's nothing new yet. Everything's kind of just hanging out. So we'll have a chance to go over that later. Yes, would you help me to repair my front door? So these are the city attorneys. They put it all together. That's surprise. They do this enough. And especially in a bigger city, they have people who handle these 1983 lawsuits like this. So, yep, city attorneys pounded it out, and then the head city attorney signed electronically. So, what does that leave then? There's a response, and this is from no, soccer child. This is Patrick Tomlinson and his attorney. They're saying, no, stalker child, you don't get it. Maybe it is you who does not understand. I cannot make my pepperoni in peace. So they point out that I love how it says that Nikki and Patrick Tomlinson offer this brief in opposition to the defendant's motion to dismiss the First Amendment complaint. And they say for the reason below, they want the court to deny it. And they're saying this is not over a single swatting. This happened over 45 times. Yeah, like they're claiming it happened a lot. They say this case not about the fact Milwaukee police responded to calls or they showed up on the doorstep to check them. 38 of these are not subject to the claims in this case because the police did nothing wrong. They said officers they confirmed the call, that it was a hoax, and then left. This is good policing, exactly how reasonable officers should handle a situation. They point out that things went way further on 7 of the incidents. The police didn't just respond to the Robinson Tomlinson home. The officers seized Robinson and Tomlinson and searched their home. On these locations, the officers knew the plaintiff's home was a known swatting location, and that there were previous calls to the residence eliciting multiple squad responses. That there was a swatting risk at this location, and that Tomlinson was disliked by an unknown community, and it seems they are determined to continually call false reports on him. The A-logs. This is where they're talking about chat. We made it. Hey, look, Ma, we made it. We're the A-logs. We made it in complaints. Also, chat, give me 1 second right here. I need to pay the water bill real quick. I'll be right back. All right, chat. So they point out the plaintiff spoke to officers, told them they were fine, asked them to leave, and informed them the call was bogus. But the police refused to listen and instead ignored the plaintiffs, then seized them and searched their home. This is what the lawsuit is about. It is not, as defendants claim, about routine police responses. There's nothing routine about what happened here. This case is about 7 occasions where officers ignored the information in front of them, unlike the other 38 times. Made it objectively clear there was no need for a reason to search plaintiff's home and seize their persons. And it's about the city of Milwaukee's refusal to respond to the request that something should be put in place to protect them. So the 7 Fourth Amendment violations. We're going to go through the 7 of them, chat, so you're going to get some lore there. You're going to get some lore now, chat. For those of you like, oh, I don't know what happened here. Well, instead of going through it, we are going to go through it now, and you are going to see it. So get ready, chat. Get ready! Although some of you are going to be wondering about, like, why are we doing this? Why are we doing it? Patrick Tomlinson, so...
Why? I don't know, some hard black stick.
There you go. I didn't stop that in the right spot. Oh, no. Okay. So the July 25th incident. They warned the police department and the FBI they were the targets of a vicious harassment campaign in April. They were swatted for the first time in July of 2022. Okay. So someone called pretending to be Tomlinson had told dispatch Tomlinson had found his wife in bed with another man and killed them both. You stalker child, you will enjoy purgatory. The plaintiffs are not bringing a claim against any individual officer for the first swatting incident. Instead, the city is liable for failing to respond to the warning. In April 2022, they spoke to the Milwaukee police officers over the phone. They told him that an online group had been harassing and threatening him for over 3 to 4 years. And I think, wasn't he getting screwed with by, like, the O&A guys, their past? I think that was what they were doing. And they said the stalkers have been making threats while pretending to be Tomlinson. They said their goal was to hurt or kill him. They had moved from online to offline. The group had been sharing pictures of themselves near Tomlinson. In other words, the stalkers' tactics were escalating. They said the other officers were not warned about the swatting threat or trained on how to respond to the calls. The officer responded arms drawn to the house, reporting a murder and hostage situation. Well, that sounds great. Tomlinson was handcuffed and taken outside of his home without clothes on. Yes, you read that right. You read that right. He was taken outside buck naked, according to him. The officer searched the home. Eventually, they realized the call was a hoax. One wrote down on the paper that revealed the Milwaukee Police Department has responded to other similar complaints at the location. They say the August 11th one. They point out that on this one, Officer Pevlik arrived, and when she was aware there had been multiple swatting calls of the home, she searched the home. They talk about in October. They point out that what cop during the August 11th stuff said emergency calls to this house are going to be an ongoing issue. And they point out that there were even more swatting calls, which I how they go back and forth. On September 22nd, there was another one. October 1st, there was another. They said the caller called it honestly, not through a 911 line, claimed to be Tomlinson, and said he had shot Robinson. So this time, dispatch noted known swatting location. The defendant, with a couple different officers, they responded with firearms and a ballistic shield. Robinson, supposedly deceased, answered the door. It's a miracle, chat. He's like Jesus. He's come back from the dead. Hallelujah. Hallelujah. She calmly explained she was fine and that she and her husband were repeated victims of harassment. The officers ordered her to get out of her home at gunpoint and search her home. Yeah, I can see why that pisses people off. And they say, here are the issues with Sergeant Evans. Okay. So he had the dongle out. All right. Sorry, guys. I'm trying to figure out my spot here. Also, if we don't get to midnight, we might run out of time here, checks. I am got to be up in the morning. So they talk about a reporter who had met with Tomlinson. That reporter had then received threatening messages from the iLogs. There are more swatting calls. And the plaintiffs bring no claims related to the calls that happened in the meantime, because all these calls, nothing happened. The home was a known swatting location, and the officers, once a firefighter, responded to the house, knocked on the door, and had a polite conversation. After the February 15th call, the plaintiffs had a note with phone numbers for emergency responders to the swatting calls. He also said he would try to make a note to try and have officers call before responding. Yeah, that would be great. Try to, that'd be great. You could like, hey, we're coming, and like, or if they hear about it, they immediately, that you, and they say March 20th with a different story. They say when the officers responded was defendant Lyndon Evans, a sergeant. Lyndon Evans. Oh, chat. Oh, Lord, chat. So, where is... I can't find it. Oh, well. Let's try to find him on here, so... All right, where are we at here? We're still going. All right. So the responding officers... Who just messaged me? Oh, nope, not a shower text. All right. The responding officers knew the house was known for swatting calls. Dispatch had warned them, swatting risk at this location. Dispatch had also warned the call made a suicide prevention line had come from a virtual private network. So there was no phone tip for the follow-ups. This was an untraceable tip. Robertson answered the door and told him everyone was fine. It was another swatting attempt. She put Tomlinson, who was not at home, on the phone, who expressed frustration and told the officers they couldn't go inside. Sergeant Evans nevertheless insisted on clearing the house, despite the fact he was acting on a completely anonymous tip that had been pre-marked as bogus, and he had made contact with two people who lived at the residence who were both fine. In other words, the fact the call is bogus was corroborated. The emergency was not. They point out the way Evans behaved is disputed, but at this stage, the plaintiff's version must be credited. And yes, it must be for now. Evans claimed he called another sergeant who said she wasn't aware the officers weren't searching and seizing during swatting calls. That sergeant said she told Evans during that call when he was there to not search the house. So apparently they're talking to each other and they're telling each other to do this or that or don't do things. But he did it anyway. He told him don't search the house. And the defendants watched this interaction take place, but didn't stop Evans. So they thought there were more swatting calls on March 26th, March 28th, and 2 on April 3rd. All right. So they point out that on April 1st, there were April 11th, there were 4 separate swatting calls. They're not bringing claims for the first 3. Well, that's because they're, oof. The 4th call is from a suicide hotline caller reported a tip gained through the VPN. This time is through a chat line. The caller thought the tip was bogus. Yeah, well, I'm glad. I'm glad the caller's like, hey, you know what? I'm going to give this bogus tip, and we're just going to send it because that makes the most absolute freaking sense to do. I don't know why you would do it that way, but hey, whatever. I don't know why. It doesn't make any sense at all. Does not make any sense. Yes, why are you gay? Why are you gay? Officer Carlton responded. He noted his report. He knew there were false calls to the house. And the Robinson and Tomlinson were the victims of an A-logging campaign. The chat claimed the two teenagers had killed their parents and were going to kill themselves. Carlton nevertheless ordered Robinson, not a teenager, out of her home at gunpoint, handcuffed Tomlinson, and searched the house. Them damn day logs. And they talk about the next day. Sergeant Evans responded again, less than 2 weeks after he searched the home. By now, dispatch is even more clear, marking the call, be advised, swatting-related call. Swatting risk at this location. And they say Evans arrived with another officer, Daniel Peterson. His report acknowledged they were both aware the home was a known swatting address. The caller pretended to be Tomlinson and again claimed he had shot his wife. Dispatch noted the call had come from an internet address in Florida. So they said when police arrived, a bystander said he hadn't heard any gunshots. They said they spoke with Tomlinson over the phone, who explained that everything was okay. And they said, nevertheless, they told Tomlinson that if Robinson did not come downstairs, he would kick down the door. So Evans ordered Peterson to kick down the door, which he tried to do but failed. Well, yeah, that's what he said. The new guy in there going to mess up. And Robinson finally acquiesced, came downstairs, showed herself, and the officers left after they're trying to kick your door in. There were 2 more calls on the 12th and 1 on the 13th. There were no claims related to those. On April 17th, someone called the Glendale Police Department pretending again to be Tomlinson and again saying he had shot his wife and then hung up the phone. The Glendale PD said she thought that the voice sounded like a recording. Even the Glendale PD was aware that Tomlinson and his wife reside at this address. Numerous calls to this situation, and it's likely a swatting call with the usual warnings. And they say Sergeant Evans responded again, this time with Officer Vento, who wrote in his report the two were aware this address was getting daily calls. Tomlinson again spoke with Evans and again told him to leave and that no one was hurt. Evans nevertheless again threatened to kick down the door and ordered Robinson to come out and show herself. There have been more swatting calls since. Tomlinson and Robinson filed this case on March 4th, 2024. So the standard review, they talk about Twombly, they talk about Iqbal again. We know they're there. We know they're there. And they say, let's get to the argument. And they say, generally inapplicable here, 911 calls reporting emergencies can justify warrantless seizures and searches. So they say that the parties find a great amount of agreement on general principles. They agree that as a general matter, 911 calls are reporting an emergency are enough to support warrantless searches. They also point out here that to carefully make credibility determinations would unacceptably delay the necessary responses to all emergency calls, including genuine ones. The plaintiffs agree on every occasion the police came to the home, the officers responding to a call in the abstract involved situations of an exigent nature. Without delving into the gritty details, the calls always involve murder or mayhem. That was the whole point. The swatters wanted the police to think things were dangerous. The goal was to trigger a high-pressure response to encounter between the plaintiffs and the Milwaukee police. Yeah. But that's where the argument ends. Untenable is defendants' positions that these general principles extend ad infinitum. Oh, you guys are talking. It's so cute in there. Say, they exist some number of provenly false 911 calls on a citizen's home that would make every reasonable officer to take pause before breaching the sanctity of the home. The defendants concede no ground here. I mean, this is where they argue, regardless of whether the defendants had any reason to doubt the veracity, they were entitled to investigate. Yep. And they point that out. They said, taken to its logical endpoint, the defendant's position is that what happened to the plaintiffs must continue. Yes, what happened to plaintiffs must continue. You must suffer. You must suffer, stalker child. Suffer. You must just take it. Just take it, Patrick. Take it all. Chat needs a summary. Yeah, well, I don't know. Isn't that what AI is supposed to do? The swatting will never and should never end short of the false callers being arrested or deciding to give up. And they say it matters not there was a single prior false call, or if there have been 3 prior false calls that same day, or if the police are responding to the 100th false call. Regardless of context or circumstance, the argument goes, if a 911 call describes an emergency, officers responding to that call are entitled to enter a home, seize occupants, and search it. Well, I don't know if that's... This is just being ridiculous. Like, but you don't get it. It's being so bad. Where's my AI summary? I don't know. They say this case is about unreasonable searches and seizures, not routine calls to service. They say, thankfully, the Fourth Amendment is not so meek, given what the Supreme Court's done yet as. And it's worth pausing to reiterate this case. This doesn't protect against the police responding to a scene, even if that response involves officers waking up to a house to try and talk with those inside. You know, they can walk up to a house and try to talk. They're allowed to do that, but yeah, they have a limit there. The Fourth Amendment protects against unreasonable searches and seizures. They say in this case isn't about the more than 38 occasions where officers responded to the home, and then after some investigating, conversing with them left. Like, that's the good stuff. We want that every time. So I just... Oh. They point out this case is about the 7 occasions in which their home was searched, where they were seized, and the officers refused to leave. They say many of the calls were not due to reports of 911. And they say it's true the duty of particularly police officers to respond to emergency situations. They point out the officers are normally entitled to presume the reliability of an eyewitness 911 call, especially where the caller identifies himself. Sorry. Ow. God. Sorry. They said, but 3 of these claims do not involve 911 calls. Instead, the police are responding to tips that came from anonymous sources to non-emergency lines. And that's where they're talking about, like, the suicide prevention lines, guys. That's what they're trying to argue here. And to put those situations back into the clear rule that the bar is not slipped, So low as to allow unreliable tips to trigger the humiliating involuntary seizures, and sometimes violent encounters we justify under the bland and familiar phrase Terry stops, much less a seizure of a person in their home and a search of the premises. They say that the seizure of plaintiffs in the search of their homes on March 20th, was predicated by a call that the officers were aware came from a VPN. The entire point of the VPN is to hide the user's actual place. Let me. Yeah, well, we're gonna keep moving here. They say, meaning the call came from a source intentionally using electronic means to hide their identity. The call came from the pepperoni, Patrick. Get out of there while you can. These were truly anonymous tips for which black letter law cannot justify. Why is it got to be black, Patrick? Come on. Black letter law cannot justify a warrantless intrusion search. Yes. These were text messages sent to a crisis text line by a third-party caller. They're saying, whatever this is, it's not an emergency 911 call. I mean, yeah, but you could argue, like, I saw this happening, so I started to help. I mean, that's, I saw, by someone being an eyewitness, like, it doesn't really going to do it. Yes, in light most favorable to plaintiffs, this court should conclude this was an anonymous tip made to a non-emergency number. I don't know if they can do that, though. That's a hell of a stretch. So, where are we at here? 13 out of 29. We're going to get through this chat. We're going to get through it here. We'll knock it out. And finally, the seizures of their home on April were predicated by a tip to a chat line for a crisis center. Although that's no different than this, really. These two are the same thing, I would argue. A chat line to a crisis center, and then just like a tip to a third party, like, yeah, I think those are the same thing. That arrow's got a wiener. In dispatch, there's no way to track the subject's info. So is an anonymous, untraceable tip. Well, yeah, but it's a little ridiculous there. And they point out that these are not related to bona fide emergency 911 calls is inapplicable. And these must fall into the well-established rule that something must be more than the anonymous call was needed to allow the defendants to enter the plaintiff's home without a warrant. The call came from inside the Airbnb. Shawsbury fraud. Does the right to examine your accuser kind of invalidate the idea of anonymous tips? No, because at some point they can receive an anonymous tip, and then that anonymous tip doesn't mean anything except for the officer to start searching or investigating. I mean, and then from there, yes, if the officer starts like my investigation based on an anonymous tip, that allows you to do that. Then you can confront the officer. But yeah, a lot of times, like there are situations of like Crime Stoppers and stuff. They try to like say like, "Oh, we promise not to give your identity away," and you're like, "Okay," and then they're like, "Sorry, we had to do it because of evidentiary reasons." So it all depends. And they say that a bunch of circuits could defeat qualified immunity. There's no in-circuit decision dead on point, and that is a growing change, but not enough yet. And they point out that claims 4 through 6 should be surviving. And they say each officer was made aware of this thing here. And they say that reporting emergency always justify a warrantless seizure or search. And they say the Supreme Court has made it clear that its decisions should not be read to suggest tips in 911 calls are per se reliable. but it is a one of relevant circumstances that you can use. And they're citing the case Navarrete v. California. And they say before Navarrete, they avoid a similar per se rule about 911 calls. The court expressly declined to exclude the possibility of a case in which it'd be objectively unreasonable for an officer to rely on a 911 call because of additional information available to the officer. And they say this is the case. And they say Richardson talked about a warrantless home entry. The exigent circumstances were based entirely on a 911 call. And the 911 operators had received a bogus call with almost exactly the same report only a week earlier. They said that an officer's subjective belief that exigent circumstances exist is insufficient to make a warrantless search. And that's because the test is objective. I find Nick shouting himself on the Baldo entertaining. But that's just kind of out of nowhere. So they're saying, in other words, the government must establish as they appeared at the moment of entry. What were the circumstances that would lead a reasonable, experienced law enforcement officer to believe someone inside the house, apartment, or hotel room required immediate assistance? Well, the AI summary is RIP. Yeah, sorry. When the officers don't know about the bogus reports, they get the benefit of the doubt. And there's no evidence indicating the system is abused so often that it's objectively unreliable for the police on a call like that. But if it starts happening, they're going to have to be. They say it's different here. Each individual officer was aware of the bogus reports. It was broadcast to them by dispatch, and the officers mentioned it in their reports. And they said that they know the 911 system was being abused, and it's objectively unreasonable for the police to rely on a call. I mean, that's a big statement there. They say to argue otherwise, argue to controlling law. The Seventh Circuit has recognized when officers responding to an emergency call, they cannot simply rely on a potentially unreliable tip when they have more information that tends to contradict that tip. Well, other than Patrick screaming like a lunatic and a list of information provided by Patrick, like, what do they have that's really challenging him? That's part of the issue here. So, in Bruce, an officer seized Fallon Bruce based on a tip from her boyfriend she was suicidal. Hold on, chat, real quick. That's even worse than a coke break, a goon break. No stalker child. All right, here, let's finish this up, chat. So they said they allowed the unreasonable claim because to proceed past pleading. And they said the officer saw this woman and recognized she was perfectly calm and rational. And her father was objecting to taking her away, and the claim should go forward. I'm pretty sure I actually remember reading about this case because it actually it sounds familiar. They said doing so, the court emphasized that determining whether probable cause exists requires a consideration of particular circumstances facing the officer. The responding officer cannot ignore these facts when assessing if there was really an exigent circumstance justifying the seizure. And there's another one where the court was unsatisfied with the argument. The officer was justified in arresting Susie Hebron solely because they received reports from two people who depicted themselves as victims of crimes. They say such reports ordinarily establish probable cause, but found the situation was outside the ordinary because the report was of questionable reliability, and the police needed to investigate it. And they say sometimes information about a person would lead a reasonable officer to be suspicious, making further investigation prudent, and because the reasonableness standard of the Fourth Amendment links a constitutional obligation to the standard of prudent conduct, the officer must do more. And yeah, I do wonder when these times where they've showed up like day after day, it's like 2 days, and that is the one time where I think that's the one time where I do think that's going to be. I would love to hear that officer get deposed. You just came here the day before and did all this. And then you came back again. What the fuck? That is the one time where I'm not trying to sweep for Patrick. But that's the one time where I do want to understand what the hell happened. That's the one thing I do want to know. Yeah, sorry, Brittany, you're gonna have to if you want to know about Patrick Tomlinson, the Farms is a great place to explain everything about him. He's a sci-fi writer who is very crazy, among other things. Yeah, there's so much about him. But yeah, I really want to know what the hell happened there. But they have a policy they have to follow each time, I'm guessing. Yeah. Um, yeah, I really want to know what happened. Like, you came by the next day, so you know it probably wasn't real, and you still went in this guy's house again. That's where I think that one might have them in trouble when it's the same officer. And they talk about in Hebron, they go back to Hebron here. You know, they came from the tenants who the officers knew were being evicted. So the people getting evicted were talking shit about their landlord, and they knew that, and that should have made it unreasonable and therefore unconstitutional to arrest the landlord on the tenant's say so. Yes. And they say here the officers knew about the situation at the home and knew about the previous swatting incidents and knew there was a group of A-logs who were determined to continually call false reports on them. The officers responding to plaintiff's home needed to do more to determine whether the calls were just the endless string of hoaxes before ceasing the plaintiffs and searching their home. And they say at bottom the law is clear, and they said when determining the seizure is justified, the precedent imposes upon police the duty to act in reasonable fashion and not take an ostrich-like approach when assessing a situation. And they say here there's information that should have made them wary on the 7 occasions, just like the other 38 times. There was no legitimate emergency. When they spoke to the plaintiffs who confirmed they were okay, any reasonable officer would have no remaining concern there was a true emergency that justified the home entry. They cannot close their eyes to facts that would clarify the situation. And they say that the officer's decision to ignore these calls and the assurances that they were fine were unreasonable. And they talk about these not being run-of-the-mill 911 calls. Well, And now they go back to talking about this issue of, well, if it's a domestic violence call, we just can't quit because those are always crazy. And they point out that the police responding to those should not abandon an abuse victim because they report being fine while their abuser looms over them in a home. And they point out here these callouts were not routine. The officers knew there was a problem here of false reports. They were responding to calls that, for the most part, reported that Tomlinson's wife had been murdered, bound, or otherwise incapacitated. When the officers arrived, she either appeared at the door or spoke to the officers via the ring camera and told them she was fine. Or Tomlinson told them that they were fine and asked them to leave. When the dispatch to a home that's a known swatting location to investigate a murder, only to find the person who's murdered you're there to investigate and answering the door is alive and well, any reasonable officer should take a step back and realize this was another bogus call. Any officer would realize there was no emergency that required warrantless entry. They say they contrast this where the court concluded that a report from a potential victim of domestic violence they were fined did not eliminate the belief she may have been in need of immediate assistance. But they point out, what did the officers do in that situation? They investigated, and they found evidence that made them realize there could still be danger. They went to speak with witnesses, discovered the 911 caller was a neighbor with her female voice saying, "Help me, help me," and heard things like furniture moving and things banging around. And yes, though they may not have observed all the violence, the other facts known to them and gathered provided them with a reasonable belief that safety was at risk and the situation was sufficient to have exigent circumstances and enter without a warrant. They said they had heard nothing corroborating the initial 911 calls, but in fact, they knew the plaintiffs were victims of a never-ending campaign of false emergency reports, which he may or may not have paid for. This makes the situation present at their home easily distinguishable from the standard call out for a domestic violence situation. And yeah, none of these are like normal in that regard. And they say the key question is whether the circumstances appeared at the moment of the entry would lead the reasonable experienced law enforcement officer to believe someone inside the house required immediate assistance. I mean, well, yeah, that's where I don't know. That's one, like I said, it's this whole issue of, do you think he calls the judge child? I think the ones where they happen like 2 days in a row, Sergeant Linden every time, it's like, yeah, you're probably screwed, buddy. Patrick might have an option here. Where did I put the tab? There we go. Sorry. They said 911 can help support a warrantless entry, but they had information they should have led him to being skeptical, and any remaining concerns should have been dissipated when Tomlinson and his wife told him they were fine. Unless you can't believe Patrick Tomlinson. Oh, justice for... Why are we doing justice for Patrick Tomlinson? The other 38 times the officers responded and realized there was no emergency. 38 times there was no exigency. There's no reason why 7 occasions here the officers should not realize the same thing. They, whoops, are bad. Or they had other issues. Betting it's other issues were going on, or the suspected. They say it's unreasonable to believe on these occasions for the defendants to believe there was any exigency. And they said the officer should have realized it was a hoax and left after speaking to the plaintiffs. They argue about the front porch's curtilage. They point out this is directly contrary to controlling law. Supreme Court has held that in no uncertain term that a front porch, part of a person's so-called curtilage, receives the same protection as the home itself, and it's U.S.V. Banks. There's also Florida v. Jardine. And they say the front porch is a classic exemplar of curtilage, meaning that it is part of the home for Fourth Amendment purposes. And they point out Detective Evans showed up, the bull. Showed up the plaintiff's porch without probable cause of an ongoing crime or exigency. He was allowed to approach and ask for a consensual encounter without implicating the Fourth Amendment. Once he was told to leave, that's it. Yes, once you're told to leave, you're no longer there voluntarily. You have to have a legal reason to be there at that point. So they point out here that this implicit license permits a visitor to approach the house, knock promptly, wait briefly to be received, and then leave. And they say to the extent any claim here rests or falls on the definition, we're not, it's a classic exemplar. And so defendants' motions should be dismissed. Like, they're like, what more can we give you? The Supreme Court has said it. So they say the right to be free from this is clearly established. And they say qualified immunity. And to overcome it, they must show that constitutional rights were violated and the violated rights were clearly established. It can be proved in two ways. Present case laws articulated the right and apply it to factual circumstances similar, or you demonstrate that the contours of the right are so established as to make unconstitutionality obvious. They talk about the court should reject qualified immunity because the contours of the right are clear. They say as a starting point, we're talking about a home here. Yes. Not a crack house, but a crack home, chat. Yes, stalker child. Not a prison, but a home. Yes, the physical entry of a home is the chief evil against which the Fourth Amendment is directed. And that's Peyton v. New York. And that's a case talking about getting a arrest warrant for somebody who runs into a home. Well, you then needed, the Supreme Court said at that point, you need a search warrant to then get into the home because arrest warrants don't allow you to enter the home the way that was done. And they say an officer cannot enter a home without a warrant or an exception to the warrant requirement. Yeah. And the Supreme Court has said that the Fourth Amendment provides equal protection to home's curtilage, immediate area surrounding the home itself. And they point out exigent circumstances and emergency aid exceptions to the warrant rule require probable cause of an exigency or emergency. And they say they say it's not complicated. They say it's easy, children. It's easy, child. Officers know they can't go into homes without warrants. And exigent circumstances or emergency aid require probable cause to believe there's an emergency. And Patrick's attorney says, consider a thought experiment. If these officers had sought warrants, would they have been granted? Probably not. And they say, as a threshold point, the inferences must be drawn in the plaintiff's favor at this stage. That's from Twombly. Remember, Twombly and Iqbal. They say the plaintiffs have not taken depositions of the officers yet. We don't know how many swatting attempts the officers were aware of when they arrived. We don't know if there are emails about it. We don't know if there are memos about it. They say they do know that the harassers pretended to be Tomlinson called in a bomb threat to Miller Park during the Brewers home opener in 2023. And they say, so it's reasonable to infer that every officer in Milwaukee was aware of Tomlinson's issues with his harassers. I mean, maybe. Another argument is the first time when the female officer showed up, there have been previous calls. The call said there was a gunshot and that Patrick had beat up his wife and that Tomlinson had a pistol. The wife answered the door, said they're having issues. The cop ordered her outside and she still searched the home. It's like, would that have been enough for a warrant? That actually might have been if it's like shots are happening right now, but she'd have to show that. This next one here where they claim she was shot, that she answered the door and said she was okay. The officers pointed firearms at her and ordered her out of her home and searched it. Would a warrant have issued for that search? And now they talk about the 18 swatting call back in March. They said when they arrived, they knew the address is known for swatting calls. Dispatch told them there was a swatting risk. That had come from an untraceable VPN. And they say Tomlinson and Robinson had told the officers they were fine. It was just another swatting call. Evans told Robinson that he was well aware of the situation. Evans called another sergeant who told him that she had told Tomlinson she wouldn't search their home. They point out and search the home over their objections. They said, would a warrant have sued him for Zoe? Like, would the warrant have been issued? I don't think so. They talk about the fourth swatting attempt of that day, count 5. Came to the VPN chat service, and he already knew that they had been prey to numerous false reports. He knew that people were determined to continually swat the home. With the A-logs just swatting the home. Despite all that, the wife was ordered out of the home at gunpoint, and they handcuffed Tomlinson and searched the house. Say, would the warrant have issued for him to do so? Is that the one where he gets yanked outside and he's naked? And literally the next day, Sergeant Evans again came to the house with a different patrolman this time. Obviously, Evans knew what was happening. He had been there 2 weeks earlier, but also the day before. But as to Peterson, who by now dispatch had stopped just saying there was a swatting risk, dispatch said, be advised. They said swatting related call. A passerby said they didn't hear any gunshots. Well, yeah, that's inconsistent that nothing happened. And despite this, they left his curtilage and tried to kick down the door and ordered his wife downstairs. Would have a warrant allowed for this? Nope. Then they talk about count 7. Sergeant Evans came again to the house, this time with another cop. They were both aware the address is the victim of swatting calls. But still, they had to show him he had refused to leave the porch to do so. Instead, ordered Robinson to show herself. Would a warrant have worked here? No. Say, are these clear violations of established law? Yes, they're arguing that. So where are they going to get to from here? So they're going to try to argue that they're... Oh, here we go. That strange situations in 1983 cases don't always lead to dismissal. Qualified immunity does not apply just because there are unique facts. Officials can still be on notice. Their conduct violates established law, even in novel factual circumstances. You'd like to think so, but they're idiots. They can talk about the widespread compliance with clearly apparent law, when it has prevented the issue from previously being litigated. They say a plaintiff is not required to present a court with a set of perfectly analogous cases. Yeah, but you try. They say this court should find the search and seizures were obviously unconstitutional. It's like, I don't think you're going to get all of them, but a couple of them are. I think there's some issue, especially when they come back day after day after day after day. Yeah. Oh, it's Denny's v. Cop. Yes. Yes. Be better, guys. And they talk about the failure to intervene in the Monell claims. So, first of all, they're going to go to the Monell claim. So, supporting the Monell claim, the complaint says that it can go forward. And they said it's pursuant to municipal policy. There's knowledge of the municipality. The policy would lead to constitutional violations. And they said the policy is the moving force behind the constitutional violation. And they say failing to train or condoning repeated behaviors qualifies as a policy. And that's true. Failing to train people or just letting somebody do something. You know, in businesses, if you own a company and your employees do it a certain way all the time because they just do whatever they want, well, that could be deemed company policy after a while in some situations. And they say we have plausibly alleged all three here. There's a pattern of violations. This gives a conclusion. The city condoned these searches. I mean, it's okay. Like, this is stretching stalker trial. I say we have knowledge. We have the knowledge. Because the plaintiffs actively contacted the city to warn them they were the victims of a swatting campaign. And at least 45 times they showed up. And then we have the causation. And say as the defendants put in their own motion to dismiss, the city's belief there is no reason to train or educate their officers on why they should deviate from the standard protocol of treating every call to the plaintiff's house as exigent circumstances led to the warrantless searches and seizures here. They're saying this court should allow the Monell claim to proceed. I mean, and it's never mind. It's not going to make any sense. Now they say the response to the callouts of the plaintiff's home on 38 occasions are not the subject of this lawsuit. Yeah, it's only the questionable ones, like 8 of them. That's there. The 7 unreasonable responses are, well, what the 7 unreasonable responses are. The officer should have come out and checked with the plaintiffs, and then once confirmed they were fine, calls another hoax, leave. I agree. They say not every officer acted reasonably, and that's what gives rise to the claims. And yes, Sergeant Evans, I think, does have a bit of an issue if he showed up. Now, if he was on the scene later, like showing if things were happening and like wasn't the, I don't know. It's going to be a little difficult. I think this one's difficult for Sergeant. Like I said, his deposition would be very interesting to watch. So, and I say, even with both Patrick and his wife asking him to leave, telling him that this was yet another bogus call, he kept on hanging in there. And they're saying the court should conclude these stages should have been obvious to the officers who were aware. The plaintiffs were targets of an endless stream of bogus tips and reports. They should not enter their home, seize them, and search them without telling them they were fine. And they say this court should conclude as at least plausible the city had a responsibility after being contacted and made aware of the situation to curb the excesses of others like Sergeant Evans. Well, it sounds like that didn't matter because he's going to do what he wants. And they're going to tell the sergeant and he'll go, no. That he refused to take into account the information before signing to effectuate the chief evil the Fourth Amendment seeks to protect, unjustified governmental intrusion. So the defendant's motion to dismiss should be denied and the case allowed to proceed forward. And I don't know, that's a little... why did that go all the way up there? So anyways, there we go. I don't think this is going to help him. I don't think it's going to help Chad. I think he's got a lot of problems here. Oh, wow. We got done within a half hour. Tomlinson just hired Robert Barnes. Yeah. I mean, maybe. You could argue about the Fourth Amendment all day long. But I don't know there. Regat says, I have a question. What would happen if Aaron went to Canada instead of stayed there? Oh, he'd be extradited. I mean, like, they wouldn't be hunting him down, but eventually he's going to slip up and, he would get caught. And yes, Canada would allow him to be extradited. The only time they wouldn't do that or have a concern about that is if there was a death penalty issue. So the death penalty issue there is a problem for some countries. Patrick is more picky than Coqueta. Well. So we are all set there, guys. Like I said, I'm curious to hear their response to why they kept showing up. Now, he might have a good answer, but it'll be very interesting to see what he says. Aaron is so hapless his charges will somehow be upgraded to a capital offense and be moved to Florida. Yeah, or Texas. Yes, I think it's very interesting in that regard. Jarek says, I have a question. What if Aaron murdered Keanu and Gino? Like, yeah, I don't know. RP says, if I want to murder someone in my house, would it be wise to call the cops on myself with a fake number daily until they stop showing up so I can get away with it easier? I mean, I would say the best way to get away with it is not doing it, because that could go up for you. But yes, there are ways and places you can do it that would minimize how much blood got everywhere, because you really need to keep track of it. Would I stream the steel toe murder trial? Jesus, no. So we will, like I said, I don't know if this is going to survive depositions. I hope it does, so we can learn a little bit about this, because, oh my gosh, it's just going to be. I just don't know how this is going to go for him when he takes the stand. Hold on one second. I'm a broadcaster now. How is he going to deal with this? I don't know. It will be funny to watch him. Does he realize he can't say like no stalker child in his depositions? That would be hilarious. But I don't know how that's going to do that there. Look like I'm narcolepsy. It's a big new arc for me. No, I'm just absolutely fucking tired. It's been a long day. So I think ultimately the court will probably dismiss it. Because literally, yes, this is like the one time where somebody's complaining the cops are doing their job too well. They're being too involved. Usually it's the other way around. They're not doing enough. But this guy, Patrick, he takes like the fucking 35 chess level move and goes, no, you're doing too much. Stop. instead of he's doing the instead of the Vince McMahon, he's doing, he's doing more. No, it's like, I'm full, I'm enough. It's like, yeah, good play. Guess I had a busy day trying to swat Patrick. Oh, so I don't know. I don't know how it's going to go well for him. I think it's, as much as we'd love to see a deposition, I don't think it's going to happen. Do I have any kind of spam policy? No. Nope. Apparently somebody wants to be in here spamming, but hey. We can see his I can kind of see his POV kind of. Yeah, I mean, really, is it his POV? Like, I'm getting, like I said, it's those 2 days in a row. I think those are the only 2 times he's really got a good answer, or they're going to he's got a really good chance to stick it to him. So maybe like 2 of the counts survive. I can see that. Yeah, Suffa chat. You're part of the Suffa cast. All we do is suffer on that. So what you guys were saying there? What the fuck? The tail of the fox who couldn't catch an answer. Brittany's saying on the day that they had a bunch of calls in one day, did they show up every time? Yeah, they said they showed up every time, but they show up and leave. So, yeah, as much as we'd like to sit here and laugh, I think we're going to get it. No, he's not going to get it. He's not going to get his depositions. They'd be funny, though. They would be funny. So, yes, Paul Harrell just posted. Yes, his brother did. Have I heard about the Julio Fulio whack in Florida? No, I don't know what that is. So if you haven't, send me an email about what's down there. Anyways, guys, that is it for today. We will get back at it tomorrow. In the meantime, enjoy yourselves, enjoy your night, and yes, remember, just because you're a stalker child doesn't mean you will enjoy prison. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stop. Just cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes it was. He even knows he's